All right, we'll call up the case of Keith Williams versus State.
May it please the court.
Good morning. Would you like to reserve some
Please reserve 5 minutes of my time for rebuttal. My name is William Pennell and I represent Keith Williams, the appellant in this case. As noted in the briefs, it's our contention that this court should reverse Mr. Williams' convictions and life sentence for 5 separate reasons. In light of the limited time we have today, I'm going to focus primarily on issue number 1 in my initial brief, the trial court's failure to conduct a proper Nelson inquiry prior to Mr. Williams' trial. It's our contention that the trial court made 2 mistakes. It failed to conduct the proper inquiry and failed to provide Mr. Williams with the proper options moving forward concerning his representation. At the outset of the proceedings on this date, on July 9, 2010, Mr. Williams' current assistant public defender told the court that he wished to discharge the office of the public defender based on a lack of preparation for his trial. It was undisputed on the record that his 2 prior public defenders had failed to take the deposition of 2 of the alleged victims and all of the state witnesses aside from the 3rd alleged victim. No valid reason was proffered for this deficient conduct and lack of preparation. They simply appeared for trial on that date, and the 2 prior public defenders had failed to conduct the depositions, despite the fact that they had told Mr. Williams that they planned to do so and would do so.
And was it your client's position that he wanted a new attorney that would then have time to prepare the case for trial? Or was it your client's position he wanted to go to trial right then?
His current public defender said he wished to discharge the office of the public defender. He confirmed that fact, and on this date said he was ready for trial and was prepared to go to trial on that date. He was put in that position to proceed to trial in an unprepared state
He wanted to go to trial, right? He didn't want it to be continued.
He did indicate that fact.
So how would the trial court accomplish that? Would he appoint a new lawyer and say, you have to go to trial today, new lawyer? Or would he say, there's a new lawyer and we're going to disregard the defendant's request to go to trial now?
The problem, Your Honor, is that he was never given the choice of giving a substitute counsel. The court...
He did have, I mean, just a week or 2 before they met for this hearing, Mrs. Warren, I think is her name, was assigned the case, and she visited with him and told him that she was not be ready, and on more than one occasion the trial court offered to grant a continuance to give her an opportunity to be prepared. And the trial court went through, I think, an extensive discussion about Ms. Warren and her experience and the fact that he found her a competent lawyer. So really, he did have a new lawyer at the time, didn't he?
He had a new assistant public defender.
Right. Your position is that the entire office of the public defender should have been discharged. And some conflict lawyer or some other lawyer appointed.
That is our position.
Do you have any precedent, any case law that indicates, and I do concede to you that I think that what happened during the year that your client spent in jail was not adequately represented. But your argument is, rather than having a new lawyer appointed, a new law firm or a new lawyer unassociated with the public defender's office, do you have any precedent or case law that says that you discharge the entire public defender's office and appoint conflict attorney in a case like this?
I do not, Your Honor. There are other cases where the public defender's office is treated as the functional equivalent of a law firm.
Right, but I'm asking you, your argument, tell me if I'm wrong now, because I want to make sure I have your argument and I understand. Your argument is the entire office should have been discharged.
That's correct, Your Honor.
And that appointing him a competent lawyer from within that office, a new lawyer from within that office, the trial court found to be very competent, but was not sufficient.
That's the...
But you don't have any authority for the proposition that instead of appointing a new lawyer, that the trial court had to discharge the entire office.
I don't have any authority. I did not find any Florida cases on point that suggested that's the appropriate remedy in this case. Again, in other contexts,
Let me ask you, just to make sure that I have the events. Your client's arrested and sits in jail for almost a year, during which time he's represented by the Office of the Public Defender. The first, apparently, 2 assistant public defenders that represent him, I think we all agree, didn't do a whole lot. He then raises this issue with the trial court. The trial court conducts what the trial court calls a Nelson hearing and says to your client, I know Miss Warren, she's a very competent lawyer. What I'm trying to grapple with is, did the trial court apply the right test? Because it seems to me that the test for a Nelson hearing is not whether the lawyer is competent, it's whether the lawyer is providing effective representation in this case. A great lawyer could be bollocksing up a case, and a very poor lawyer might be doing a great job. And Miss Warren admitted that she was not, and although she was capable, I know Miss Warren, I know she's capable of providing good representation, but she admitted that she wasn't in this case because her predecessors had done squat. And now this guy wants to go to trial after a year, and he's got to go either on his own or with a lawyer who is unrepresented, or take a continuance. And is that what happened in the case?
That's what happened, Your Honor, and that's the first problem and the first mistake the trial court made here is...
Because to me, the focus is, did the trial court apply the right test? I'm not so convinced that the trial court did. Now, whether it's harmful or not, it's a different story. But the test to me is not whether she's a competent lawyer. I think we'll all concede she is. Well, you don't have to concede it. But let's concede that she is. The question is, could she provide, or was she providing effective representation in this case? And I think the answer in my mind is no, because of the actions or lack of actions of her predecessors.
Well, then, if that's, here's my question, if that's the case, then let's assume he had, appointed another lawyer. It seems to me that like what we're saying is that we're attaching the incompetence or failure to properly represent to the new lawyer as well. It seems to me that the remedy in this case should have been, had the trial court found that the attorney was incompetent to appoint a new lawyer, right? And had the trial court appointed a new lawyer, we wouldn't be here today, would we?
We would not.
All right. So the question is, Ms. Warren had just been assigned the case. She couldn't have provided competent representation because she had just started. And so it seems to me that if we are to say that despite the trial court's finding that she was a competent lawyer but didn't have an opportunity to do anything because she was new to the case, it seems to me we're taking the remedy that you say the trial court should have applied, and the trial court applied that remedy anyway because she was a new lawyer. She had just been assigned the case, and the trial court found she was a competent lawyer. Give her an opportunity to try, and that's what the trial court was telling your client to do, right?
That's true, Your Honor, but the problem, I think, with the court's analysis in that respect is if you could have 10 assistant public defenders drop the ball for 4 years, and then if you appoint a new lawyer on the date of the trial, then you could always make a finding that that person is competent and hadn't done anything incorrect. Here, it was completely...
That goes back to my point. You want the entire office discharged. Not a new lawyer appointed from within the office. You want another lawyer appointed from without the, from that's not employed by the Office of the Public.
That's correct, Your Honor, and I think that's reasonable under the
If-
circumstances.
If the public defender's office had a conflict, for example, they couldn't, they were representing a co-defendant. You don't just disqualify the one lawyer that's representing the co-defendant. The public defender's office is treated like a law firm. If one lawyer's out, they're all out, aren't they?
You discharge the whole office and you appoint the regional conflict counsel, which is,
This is not a conflict case. The issue in this case is whether there was an appropriate, obviously Judge Ortner and I have a difference of opinion here. But this isn't, you haven't alleged there was a conflict here. You're alleging that there wasn't a proper Nelson inquiry.
correct, Your Honor, but I think there's some analogies to a conflict situation because it's completely reasonable under these facts for Mr. Williams to be unhappy with the deficient performance he was provided by the two assistant public defenders, and for him to want to discharge that office. And there's a system in place.
Let's go back to the facts. One lawyer was on medical leave, right? And then the other lawyer that took the case resigned from the office. And so Ms. Warren was appointed, and she visited with him the night before, or shortly before the trial, and told him that she had been newly assigned to the case, she was representing him, and she wouldn't be ready to go, and she would request a continuance. And your client insisted on going to trial that day, right?
He did, but he wasn't given the option, he was never given the option like the case law requires to be provided with substitute counsel. So he wasn't given the
But why should the trial court give him that option when the trial court found that his newly appointed lawyer, from what the trial court knew was a competent lawyer,
'Cause that's-
was willing to give a continuance to let her try the case?
Your Honor, because that's not the appropriate test under the circumstances. The appropriate test is not whether Ms. Warren, in her career as a competent attorney, it's a case-specific inquiry as to whether the lawyers that had represented Mr. Williams had provided him with competent representation.
Is the question whether Ms. Warren has provided him with competent representation, or is it the whole history of the lawyers who, let's say Ms. Warren was put on the case 6 months ago. At the Nelson hearing, could the defendant complain about what the first public defender had done a year and a half ago? Or do you just look at whether or not the current lawyer representing the defendant has or has not acted appropriately?
I think you look at the current status of the case, and the offices of the public defender was not ready for trial on trial day. They were not ready to go. They had more than sufficient time. So in this scenario, you look at the whole body of work.
But you replace a lawyer because for some reason that lawyer can't do the job, right? In
Sure.
essence. Ms. Warren was brand new on the case. Why could somebody outside the public defender's office do any better job than her? They would both be faced with the fact that the public defender's office had dropped the ball for the lawyer.
But her office had put her in that position. It was reasonable for Mr. Williams to want to discharge counsel, their office, and to lose faith in that office under these circumstances.
So anytime there's a Nelson hearing and you're represented by the public defender, if you prove that the public defender has not done what they should do, you're always entitled to an outside lawyer rather than another member of the public defender's office?
I think you have pretty extreme facts here. You have a case where the defendant is facing
But
life
answer
in
my
prison.
question, maybe they're not as extreme facts. Is it your position that if a Nelson hearing determines that a lawyer from the public defender's office has not provided proper representation, that the defendant is always entitled to the appointment of a new attorney from outside the public defender's office? And is there case law to support that proposition?
There is no case law on that specific issue, but I think the case law that says the public defender's office should be considered a law firm is analogous and should be applied in the situation. So I guess the short answer to your question is yes.
You got 2 minutes.
I'll reserve the rest for rebuttal.
May it please the court, counsel, good morning. My name is Kelly Neal, and I'm here on behalf of the state of Florida.
Ms. Nealon, did the trial court conduct a proper Nelson hearing?
I don't really know that this was a Nelson situation. It was sort of a hybrid, I'm just not happy with my situation and I want to go to trial today. And in terms of that, the trial court kind of pigeonholed it into a Nelson situation. And for the situation that it was, I think, yes, he did do a sufficient inquiry.
Is the inquiry at a Nelson hearing, and I'm looking at Nelson, I'm reading from it, it says, the test is whether or not there's reasonable cause to believe court-appointed counsel is not rendering effective assistance to the defendant. If reasonable cause for such belief appears, the court should make a finding to that effect and appoint substitute attorney who should be allowed adequate time to prepare for the defense. So I guess in my mind, the first inquiry is appointed counsel rendering effective assistance to the defendant?
Ms.
Now, in
Warren?
this case, the appointed counsel, the court doesn't appoint Attorney X or Attorney Y of the Public Defender's Office. The court appoints the Office of the Public Defender. So, and as Judge Sawaya noted, he and I may have a little difference of opinion, at least on this issue. It seems to me, I mean, it is the test whether or not the Office of Public Defender has represented effective assistance of counsel to this defendant, not whether these lawyers are in and of themselves generally competent.
I think at the point, it's the lawyer who is representing him at that point in time, if that lawyer is providing effective assistance.
So the fact that if the Office of Public Defender, and again, you know, if they did nothing for the prior year, but on you know, the day of the Nelson hearing, the public defender appoints their top gun, that's good enough in your mind?
Well, it could be. That wasn't the situation here. It wasn't on the day of the Nelson hearing, and this wasn't even a pre-filed motion to dismiss counsel. Like I said, this isn't really your standard Nelson type of situation. It is a little bit different in the trial.
But it was enough where the judge recognized that he needed to conduct a Nelson hearing.
Correct.
So he tried. My question is, did he succeed? Did he ask and answer the right question? And the question is court-appointed counsel rendering effective assistance? Who was court-appointed counsel in this case?
Well, Ms. Warren through the Office of the Public Defender.
Is there any order in the court file that says Ms. Warren is the appointed attorney?
I don't believe so, no.
The court appoints the Office of Public Defender. And in fact, there's a lot of cases out there that say the court doesn't have the authority to tell the public defender or the clerk of the court or anybody else, you must put Kelly Nealon on this case. You must put a public defender X on this case. All the court can do is say, public defender, you're on the case. And then the public defender runs his or her own office. So help me understand if the court asked and answered the right question. Is court-appointed counsel providing effective representation?
I think the strongest evidence of court-appointed counsel providing effective representation is what she did in this case. She went in, I went to the jail and saw him, I explained to him that I am not prepared, I need to let the court know that I'm not prepared for this, I will become prepared for this in short order as soon as I can, but he wants to go to trial right now. And that's where the twist in this case is. And perhaps if he had filed the motion 6 months earlier, when there was no one actively looking after his interests, perhaps at that point the public defender's office should have been discharged. But at the point in time that this occurred, under the situation that this occurred, he did have effective counsel.
Let me just follow up now. Assume, and I understand that you and I perhaps may have some difference of opinion on that initial inquiry. Just assume for the sake of discussion that my view is correct, and what the court should have done was, the second part of Nelson is if there's ineffective assistance, to appoint new counsel and provide appointed counsel adequate time to prepare. Would that have been a meaningless act in this case, given the fact that A, he had a lawyer who the court found was competent, but more importantly, this guy said, I want to go to trial right this minute. So even if the court had appointed outside counsel, that counsel would not have been able to do any more than Ms. Warren did, given his insistence on going to trial right then.
Correct.
Is the failure to conduct the proper Nelson inquiry or to to apply the test properly, subject to a harmless error analysis, if it would have been futile anyway. And I'm more interested in the futility side, because I think on that point, Judge Sawaya and I may agree that given his insistence, I want a trial right this second, wouldn't have made any difference who came in the case.
Correct.
Is it subject to a harmless error
I think it is
analysis?
subject to harmless error analysis. Again, I mean, what we look at is here is,
The case law says it is, right?
yes,
Okay. That brings the cases that say that failure to conduct any inquiry, and I think we all can see this was a Nelson inquiry, the failure to conduct any Nelson inquiry is reversible per se. But in terms of whether it was adequate or not, we apply the discretionary standard and harmless error analysis, right?
correct,
The case law is clear on that. right?
correct.
Okay, just making sure.
It is, and I mean, that, if he would have agreed to a continuance, and 2 weeks later he came in and said, Ms. Warren's done nothing in the last 2 weeks, I want another attorney, then I think you would have had some ground to stand on,
What
but,
would the court have done? Let's just to understand what the state's position. So let's say that, you know, the court gets them to agree to a 2-week or 4-week continuance, and now we come back a month later, Ms. Warren says, you know, I just got busy and I couldn't get to the case, so I haven't done anything. Does the court now have the authority to discharge the public defender and bring in either conflict counsel or the office of, I can't remember what they're called. You know what I'm talking about.
yeah, the conflict.
Conflict
Yeah, yeah.
counsel office. Does the court have that, or does the court say, oh, Ms. Warren, I'm going to boot you off the case, tell your boss to bring in yet another one off the bench? What's
No,
the
I think-
remedy at that point?
Well, I think the court can appoint outside counsel at that point, if counsel comes in and says, I'm ineffective,
So
and we have a history of this man just sitting in jail
do you
being,
agree at least with that
Be-
part of Mr. Pinal's argument, that the court would have the authority to boot the public defender out and to bring in either the office of conflict counsel or external counsel if they couldn't do it for some reason?
yes, I think if current counsel that was representing him at that
The
time,
trial court would then have to make a finding that the office itself was not common.
correct,
But if the trial court makes a finding that the newly assigned attorney is competent, that takes the issue away, right?
correct,
All right.
which is exactly what the court did in this case.
Yeah, all right.
Well, I think that's probably where perhaps the three of us, at least you got 2 votes here apparently. It sounds like I've only got 1, but I don't think that's the test. I don't think the test is whether the lawyer is competent. I think whether the lawyer providing competent representation. A great lawyer could bollocks up a case.
I agree with you 100%, but the fact that she went in there and said, I just got the case, I am preparing, I can't do this now, I think that shows she was providing competent representation. She could have just gone in there and said, oh, this is going to look
Her inability to properly
horrible.
represent him demonstrated her inability to properly represent him.
At that time. At that time, not after she had an opportunity to prepare. And again, even with what you believe is the proper standard, I would say it had to have been harmless, because the bottom line in this case was he wanted to go to trial that day. So I would ask this court to affirm. Thank you.
Thank you so much. Mr. Pinal, tell me why all of this isn't much ado about nothing, in that even if the court applied the wrong test, as I think it did, given your clients, given what Nelson says if the lawyer isn't doing a competent job, you remove the lawyer, appoint new counsel, and give that lawyer time to prepare. It couldn't have been more clear from this record that your client did not want to give any lawyer time to prepare. He wanted, and I don't blame him, he'd been sitting in jail for a year, but he wanted to go to court right then. So why isn't this harmless error, given the fact that even if the court had jumped through what I perceive to be the right hoops and said, okay, we're throwing them out, we're putting in, lawyer X, who is the top gun in Florida, and we're going to give you time to prepare. No, I want to go to trial right this second.
The reason it's not harmless, Your Honor, is because Mr. Williams was never given that option. It's clear from the record, from what Ms. Warren said, from what he said, that his beef, and he was upset with the Office of the Public Defender. For a year, they hadn't prepared for the case. We don't know, because he wasn't given the option, what would have happened had the court appointed substitute counsel, had he been provided an opportunity to speak with that counsel, and at that point, he may have requested a continuance and allowed that lawyer to prepare. He was never given that option, inappropriately.
I'm not so sure Judge Workman and I disagree all that much. My point is that the trial court said that this was a competent lawyer, and the trial court had no basis to find that this particular lawyer that had been recently assigned to the case had rendered ineffective assistance of counsel because she'd just been assigned the case. She was just on it. I mean, had she had a track record of doing the same thing that the other two lawyers did, then that would be something different. But to me, it goes back to the remedy. Here, and I think you conceded earlier, that the remedy would have been for the trial court to appoint new counsel. New counsel was on the case. He received the remedy. You're saying the remedy was insufficient because the entire office should have been discharged. And I'm saying that there was no basis for this trial judge to say that the attorney that was currently assigned to the case had done anything ineffective because she had just been recently assigned the case and started to work on it.
Your Honor, I believe the problem with that analysis is that you could have 10 lawyers from the public defender's office drop the ball, not prepare for trial.
Eventually, you get to the point where the trial judge says, you know, there's just not going to be anything coming out of the office itself that's going to render competent and effective assistance of the counsel. And maybe at some point, you know, he says, okay, we'll just appoint an outside lawyer. But I think it's telling that there aren't any cases that have said that is an effective remedy. And it seems to me it would be an effective remedy only in the instance.
Judge, I think we're at that point when the guy's facing life in prison and he sat in jail for a year and no depots were taken. We're not talking about collateral witnesses. We're talking about alleged victims of sexual battery.
I'm reading the transcript, and I've read it more than one, the entire transcript. The transcript of this hearing, it runs about 25 pages. I think it's pretty clear, as Judge Wolfinger pointed out, that it didn't matter whether your client was appointed the best lawyer in the world at that particular time. He was going to go to trial. He said he was ready, and he made that statement on a number of occasions in the transcript. He didn't care. He wanted to go to trial that day.
The problem with that, Your Honor, is we don't know because it wasn't done and the court was required to do it. The court was required to appoint substitute counsel and didn't do it.
You've exhausted your time.
Thank you, Your Honor.
Thank you both.